John, let me start with you. So this means Uber will be regulated on a country-by-country and even a city-by-city basis. What does that mean for it?
Well, the reason that Uber took the challenge was because it wanted to... the EU-wide regulatory regime would be slightly more favourable to it. And if it were determined to be a digital services provider, an information services provider, then it would have been regulated at the EU level, and, if you like, further obstacles would be potentially in its way to restrictions. But being regarded as a transportation services provider, it's regulated at the member state level because that's a derogated area.
What is that going to mean in terms of Uber's costs? Is it possible to put a number on it?
It probably is. I won't venture to try to put a number on it. I've seen some commentators saying that if the drivers are regarded as workers, then they'll no longer have self-employed status, and then potentially VAT would be applicable. Yeah. So I've seen some comments along those lines, which would be quite significant. That would be 20% on the cost of each journey. Well,
James, let me bring you at this point. So 20% on Uber's costs. Presumably that is all going to get passed on to the poor old customer at the end of the day.
Well, it may or it may not. I mean, at the moment, Uber is enjoying a benefit of underpaying drivers below the minimum wage. A lot of drivers have been propped up by the welfare system. So there is no such thing as a free ride. But I think what we're seeing with the ruling here today is that Uber's business model fundamentally is in tatters now. And what we're seeing is that a failure in regulation in the United Kingdom in terms of employment law, in terms of taxation law, in terms of transportation law. And every time we go to court to challenge the regulation that we've had, our regulation comes up short. The Taylor Review hasn't answered this question either. So when
this is Matthew Taylor from the RSA.
That's right, his review of modern employment practices for the government for the gig economy. When we went to tribunal against Uber, Uber argued that it is the agent of the driver and that we are the principals in the business. Now, our judge in the tribunal over a year ago said this was pure fiction, and the European Court of Justice has agreed today. What that the knock-on effect of that is that Uber has previously sort of argued that, well, the driver is responsible for VAT, and since we're all below the VAT threshold of £85,000 and low income, then nobody pays VAT. Now, all of a sudden, Uber could have to pay that VAT. And the other thing is its initial public offering. Uber went to the SEC in October and argued this agency principle argument, that it is merely an agent, it is not a transportation provider. The SEC accepted that, but since then we've had an employee appeals tribunal has ruled against that, and so has the European Court of Justice. And finally, the HMRC went before the Public Accounts Committee last month, and they said that they were looking at two important cases to determine how they would go forward on taxation with Uber. And one was our case, which we subsequently won, and the second was this case, which has now come in favour of against Uber. So, in the new year, maybe in 2018, HMRC will take a run at Uber. Let's see.
Right, OK. Well, John, the European Court of Justice can often be quite vague in some of its rulings. It's been very, very precise here, hasn't it?
Yes, I mean, it was a relatively short judgment for the European Court. But, yeah, I mean, it was the choice, really, between is it a digital service or is it a transportation service? I think they probably had some sympathy with Uber. I mean, they had to obviously consider the position. But they have a doctrine of the centre of gravity, and once they looked at, is this more an information society services sphere, or is this more a transportation sphere? I suppose it was irresistible that they said, you know, in reality, it's a transportation service, so that's where, you know, where we have to land, and that's where the regulatory implications will follow.
This is actually quite pertinent, though, to the Brexit debate, isn't it? Because, I mean, this highlights how difficult it is to get a single market in vast parts of the services sector. Big problem for the UK, potentially, because we're a services economy.
Yeah, I think so. I mean, well, in this particular case, they've decided that actually transportation is an area that's within the influence of member states. So I suppose to that extent there wouldn't necessarily be a Brexit implication of this. But I think that's right. It's always an important topic.
All right, James. Very briefly, what does this mean for other companies operating in the gig economy? Do you think this is going to have an impact elsewhere, companies like Deliveroo?
Well, the common factor here is that a lot of these companies reinvented themselves. They position themselves as digitised firms in the cloud with no real infrastructure responsibility on the ground. But of course, somebody has to get on the bike and deliver your food. Somebody has to drive you from A to B in a car. And with that comes responsibilities, whether it's employment law or taxation and so on. So I think that's the big lesson here. That's what we've went to tribunal to prove, that we're workers, that we're entitled to the minimum wage.
All right, James Farrar, John Doherty, got to leave it there. Thanks for joining me.
Thank you.